the great state of Florida in this honorable court.
Please be seated. Good afternoon and welcome to the First District Court of Appeal. We have only one case on our docket this afternoon, Kokomo Key Properties Incorporated, doing business as Swamp Car Washes, versus Lynetta Carter as personal representative of the state of Bobby Hopkins. Counsel, if you're ready, you may proceed.
And Your Honor, I'll just note up front, I'd like to reserve 5 minutes for rebuttal if I can.
So noted.
May it please the court, I'm Nico Athanas with the firm Carlton Fields, and I represent the appellant in this case, Kokomo Key Properties, which I'll refer to as Kokomo. With me at counsel's table is Mr. Peter Webster, also of Carlton Fields. Your Honors, this case is about a fight that broke out between plaintiff's decedent, Mr. Hopkins, and a known acquaintance based on a personal dispute resulting in Mr. Hopkins' death. Now, this fight could have happened anywhere, but because it happened at my client's car wash, plaintiff says it was my client's fault. At trial, the jury's view of the evidence was distorted by the errors on appeal, resulting in a verdict in plaintiff's favor of more than $7 million in damages. And I want to focus on two issues today for the court. The first is the exclusion of evidence of the deceased's prior convictions and incarceration, and the second is plaintiff's counsel's admittedly improper impeachment of Kokomo's key expert witness. So starting with the exclusion of evidence of the deceased's convictions and incarceration. So Your Honors, this exclusion caused the jury to evaluate highly subjective, non-economic damages categories without evidence that was crucially relevant to the value of those damages. The jury just didn't have the full picture here. And what was that picture? So there were 3 convictions that the deceased was subject to. First was a felony conviction for felony trafficking in cocaine, and the second one, of particular relevance here, I'd say, is possession of a location for drug sales in the presence of a minor. And the relevance of these prior convictions boils down to the fact that surely some reasonable juror could find that a deceased's felony convictions have at least some logical tendency to affect the value of their parental instruction and guidance.
Did the trial court apply the incorrect law to this, or did he, just according to you, abuse his discretion in allowing the evidence in?
Your Honor, I'd say that the court didn't recognize the threshold relevancy of this evidence, so then in applying the 403 balancing test, which is ultimately what the court used to exclude this evidence, the court abused its discretion in applying that balance.
Okay, thank you.
And counsel, real quick, just to be clear, what was the exact nature and scope of the evidence that you contend the trial court should have admitted? Is it just the fact of the convictions and the incarceration, or I think in your brief you had said evidence related to, and you know, what's the exact nature and scope of what you wanted to have admitted?
So for us, it's 2 things, and Your Honor just referred to both of them. So it's first just the existence of these convictions and what the convictions were for, and the second part of that would be the incarceration away from the children for those 3 formative years.
All right, and initially, when this was first presented to the trial court, though, you weren't really arguing about the damages claim, right? It was more dealing with the defense that your client was raising.
Both of those issues were discussed at the very beginning of trial, so this issue was addressed several times at trial, and it first came up in a preliminary discussion where the court wanted to get a feel for the issues before voir dire, and at that point there was some discussion of maybe a propensity inference, but even at that point they were also saying this is relevant to pain and suffering damage, this is relevant to parental instruction and guidance, and when this issue came up later, that issue was discussed at length, and the court said multiple times, excuse me, let me find this. So the court's reasoning was Mr. Hopkins' criminal history is irrelevant at this time. I don't believe that it's relevant to damages. I don't believe that it's relevant to any issues in this case. When it came up again later, his felony conviction is irrelevant in my mind when it comes to the relationship between the children and Mr. Hopkins. And that was again in that discussion of damages. So the court was certainly focused on this issue. And despite that and this argument being articulated, the court found that there was zero relevance to this on the issue of damages. And we think that that was plainly incorrect, and that, Your Honors, infected the 403 balancing analysis, which is ultimately what the court used to exclude this evidence. And as the court surely knows this is a test that strongly favors admissibility. You can only exclude the evidence if the danger of prejudice strongly outweighs, or substantially outweighs the probative value. So on the probative side of that probative side of that balance, the court was operating from a place of zero, right? The court concluded that there was no relevance to this at all. So starting from that point, any weighing that the court's going to do against potential harm is just defective from the start. And for that reason, while this is a subjective test and the test is abuse of discretion, I'd say that we really can't defer to that analysis, because on that probative value side of the balance, that finding was just erroneous.
The decedent being away from his kids for 3 years certainly has some relevance to the damages. What's the relevance, though, just in the abstract of the criminal conviction? What was trying to be shown by that?
Your Honor, I think it's just the fairly intuitive fact that if you're talking about, and to put a finer point on this, I want to reference the way the plaintiff's counsel explained these non-economic damages at trial. So what plaintiff's counsel said to the jury is that these damages reflect the moral compass, their ethics, the world values that the deceased would have passed on to their children. We're looking at the value of that. So if that's what the jury is assessing, surely prior felony convictions and the implications that come with that could factor into a juror's analysis of what the value is of those ethics, that world values, that moral compass that would have been passed on to those children. And as Your Honor referenced, there's independent relevance with respect to the incarceration. So apart from the fact of convictions, the incarceration, during that time, there were serious restrictions on the deceased's ability to communicate with his children, and there was a qualitative difference in the way any interactions could occur as compared to if the deceased had simply been out of town, right?
Well, you're presuming that, but was there any evidence proffered? The judge talks about, well, they have iPads in prison now and they can make phone calls and such. He's apparently a former prosecutor and has familiarity with the state prisons. What evidence was there that his ability to communicate with the kids was more different than just somebody who's working on an oil rig out in Texas for a few years?
Well, Your Honor, it was never discussed explicitly. In the argument, I think it was essentially a recognition by all that when you're in prison, there's just certain rules that apply. Any visitation, to the extent there was any, would have been supervised, it would have been time limited, and I think we can also assume that merely having to go to the prison to be engaged in a visit could be intimidating to the children. And I think the point here is that whatever the circumstances were of him being away, whether he was out of town, whether he was in state prison, or I think whether he was in a Russian prison is the argument that's made in the brief, the particular circumstances of the absence are relevant to precisely how that affected the relationship at those times. And that relationship is the basis of these non-economic damages. We're looking at...
Right, but even if we agreed with you that it was relevant to the damages, why did the trial court abuse its discretion? And we're looking at this, let's say, on the tipsy coachman, even if he got articulated the standard incorrectly, why wouldn't it be unfairly prejudicial here when you were raising the defense that the defendant was committing a felony at the time of his death?
So, Your Honor, the first thing I'll say is we're operating under the 403 balance, like I said, and just framing this conversation to say that we're dealing with an improper relevance assessment. But on the other side of this, the primary danger that appellee has raised is a concern of a propensity inference, right? And best I can gather, the concern is if there's prior felony convictions, the jury might think he's a bad guy, and that might taint their view of the incident, right? But in this case, there's really no room for that kind of propensity inference because of the evidence we had. This incident was caught on video. And I think, I'd say it would be different perhaps if there was competing witness accounts, right? If you had two verbal accounts saying this is what happened and another one saying this is what happened, the jury might fill in that gap with some propensity inferences. But in this case, the best evidence of what happened, and surely what the jury would have relied on, is what they saw with their own eyes. And I think...
But certainly jurors can draw different inferences looking at the same video. So, I mean, it's not, you can't suggest that the fact that he was convicted wouldn't have shown some kind of propensity that would have added to whatever inferences they're drawing from the video, right?
Your Honor, I'd agree with that, but I'd qualify it as it's a matter of degree. So since we have this video, any role that other evidence is going to play is just going to be substantially minimized. The jury's first going to be looking at that video and seeing what happened between these two individuals. So if there is any propensity risk here, it's just highly minimized by the evidence that we had of what happened, and it certainly wasn't so prejudicial as to substantially outweigh what we think was highly relevant an extremely probative piece of evidence on the issue of damages.
Well, let's talk about the probative part of it. You also, though, were able to get in that there was a drug deal happening at the time of the death of the decedent. So why isn't that enough to show kind of that, I think, bad character, bad influence, poor parental guidance that you were trying to get at?
Your Honor, I don't think that mitigates the harm at all, and here's why. So plaintiff, in their brief and at trial, repeatedly impugned the credibility of the convicted shooter, and that is the only place that there was any reference to prior drug activity, illicit activity on the part of the deceased that came from the shooter's testimony, right? So plaintiff's counsel, that was a big part of their case to say that couldn't be believed because there was self-interest involved there. So that made this other evidence corroborating that prior criminal history all the more essential to show that this wasn't false, as was the implication of attacking the credibility of that other evidence, Your Honors. And if I may, I would like to transition to the improper impeachment issue in my few minutes here before rebuttal. And as I said at the start, this issue is the improper impeachment of the defense's sole expert witness, Mr. Kelly Klatt, with expunged 35-year-old misdemeanors. And to give you a little bit of context, this was defendant's sole expert witness, and he was testifying on issues related to crime prevention, as well as liability in general. And on this issue, we have conduct by trial counsel that was undisputedly improper as a matter of Florida law, and that was because plaintiff's counsel didn't have in her possession a certified copy of conviction when she asked her impeaching question. And I'll just note that that's on top of the fact that these are 35 years old and expunged and wouldn't have been proper to use for impeachment anyways.
Right,
Well,
so if we agree it was improper and we agree it was remote, why, you didn't obtain a ruling from the trial court on that, so why would we find this as preserved, and why would we reach this?
So, Your Honor, I think the record makes it explicitly clear what defense's preferred remedy was at that time. There was a contemporaneous motion for mistrial, and it was also raised post-trial. At neither of those points did the court grant that relief. And it was the first thing out of trial counsel's mouth at sidebar was, Your Honor, I move for mistrial. And I think that's what we need to look at in terms of preservation. And I'd also note that...
Let's stop. I mean, you also, your client asked for a curative instruction and received it. And again, there's never in this record a ruling on the mistrial motion.
I think we have to look at the sequence of events. So the way this happened was the improper comment was made, immediate sidebar, first thing that's said at the sidebar, starting with, Your Honor, we'd like a mistrial. At that point, the court asked counsel, plaintiff's counsel, what's going on here? Do you have a certified copy of conviction? She says no, immediately drops it, backs off. The court says, at that point, okay, sort of indicating that he's ready to move on. At that point, after initially requesting the mistrial, defense counsel says, well, Your Honor, can we get a curative instruction? And I think the fact that this was renewed later, post-trial, again, made it very clear that we thought that a new trial or a mistrial was the appropriate remedy to cure this prejudice. And I also want to note that plaintiff hasn't said otherwise in their brief. Nowhere in the answer brief did they argue that this issue wasn't preserved, so they seem to be operating from that same understanding on the impeachment point.
Well, when the trial counsel, though, says, there's a discussion of this being improper. Clearly, in my view at least, it's improper. That should never have been asked. It's possibly contemptuous from trial counsel to do something like that. But after moving for a mistrial, then counsel says, I asked for a curative instruction in the jury to disregard that question. Granted, tells the jury to disregard, it's stricken, and then no further questions, and then with that redirect, thank you, Judge. No further discussion there. I mean, it seems like it might even be arguably waived as opposed to not even preserved, in that he first moves for mistrial but then moves for curative instruction. That's granted, and then moves on without even mentioning mistrial again.
So, Your Honor, I'll give you what I think is the short answer, and then I want to point you to some case law on this. But essentially, we have this initial request for relief, and we have someone settling for other relief because it was clear that that relief wasn't going to be granted, the preferred relief. And again, it was renewed post-trial. So
how was it clear? I mean, that's what I'm looking for in the record. I mean, if you go to the transcript at 859 through 860, where is the clarity that you're arguing about right now?
I think it's just in the fact that plaintiff's counsel withdrew the question and the court said okay. and was ready to move on. But I do want to point you to some case law that I think is relevant on this issue. And the first one is Albertson versus Stark. And to give this a little bit of color, we argue in our brief that the fact that this transgression by counsel appeared to have been deliberate, unfortunately, counsel strongly in favor of reversal under the case law. And first, in Albertson versus Stark, this is the 4th DCA case, the court there reversed based on improper attorney argument, despite the fact that a curative instruction had been given, and there no motion for mistrial was made at all. So there wasn't even a question of ruling, there was no motion for mistrial. That aside, the court said this was, quote, a deliberate tactic, and said where any such improper conduct occurs, the court should not hesitate to set such verdict aside. I also want to point you to this court's holding in Boyles versus Dillard on the same point. So there, just like here, there was undisputedly some improper argument made by counsel, and a curative instruction was also given there. The court reasoned, quote, a finding of harmfulness is especially appropriate when the context suggests that the error was made intentionally, and reversed on that basis. So, Your Honors, I think that's an aspect of this that can't get left, is the deliberate nature of this and how that factors into a finding of harmfulness. And I'm running out of time here, so I just quickly want to note that we also raised some substantial issues that arose in closing argument in our briefs, and I didn't have time to touch on those today, but we think the briefs show why those issues also merit a new trial.
Thank you, counsel.
Good afternoon. May it please the court. Brian Gowdy for Ms. Carter on behalf of the Hopkins estate. I want to start where my friend just ended. We agree the second issue was not preserved. It is true we didn't make an express argument in our answer brief on that, but I did submit some supplemental authority on Friday. The entire, it's only 2 pages of the record. It's pages 859 and 860, most of it's on 860. And I think the fundamental problem here is that, yes, there was a mention for a mistrial at the beginning, but then once the question was withdrawn, Mr. Vasquez, the defense counsel, said, I'll ask for a curative instruction and the jury to disregard that question. Then the objection is sustained. You can't appeal a ruling in your favor. And then the judge gave the curative instruction that was requested. So you can't appeal that because the judge did what you asked. And so it was then incumbent upon defense counsel at that point in time to say that even with the curative instruction that was just granted, effectively the skunk was in the jury box and I should get a mistrial. And that was never asked for, and you were right, Judge Rowe. There was not a ruling. You contrast that with the issue dealing with the wealth comment, which I want to get to. The judge there denied the mistrial. Here, the judge never denied the motion for a mistrial. I think the judge believed, if you read the transcript, that he had taken care of the problem because he granted the curative instruction that was requested by defense counsel.
Well, how do you deal with the cases that appellant has just cited on Voiles and the 4th DCA case dealing with, again, this is such a, I mean, this was deliberate. It was clearly remote, and almost inexcusable from a contempt side of the house. So why shouldn't we find this skunk in the jury box kind of fundamental error here?
Because I don't think that changes the preservation analysis. And I unfortunately, I haven't seen those cases you just mentioned. I tried to look at them very quickly. I'm not sure if they were cited in the briefs or not.
They were cited.
Okay.
So I think that, in terms of that kind of, is there anything that you could ask a criminal defendant about, their crimes of dishonesty or things like that? It seems a little shocking, and especially where this fell at trial, for this kind of question to be asked and then just left hanging.
Right. Well, again, Your Honor, the curative instruction was given as requested by defense counsel. The judge gave it, and at that point in time, defense counsel never said, well, that's not good enough. The judge sustained the objection. So you don't have an adverse ruling in front of you. And they did not argue at any point, and have not argued today, fundamental error. So without an adverse ruling in front of you as a court of appeals, I don't see how you can reverse this trial judge. I just, and it, even no matter what you think of how improper the comment was, you still are constrained as an appellate court when reviewing a trial judge, and that you can only reverse the trial judge if he issued an adverse ruling to this party, and they can't point you to one. And I would suggest the reason is that they were happy at trial when the judge gave the curative instruction and they were ready to move on. And if they weren't, they should have told the judge that, but they didn't. And he did not deny the motion for mistrial. It's not in the record. Just on the two, I know that the other side didn't comment on it, but I wanted to make clear too, first of all, one of the two comments during closing, there was no objection. The Murphy test, the four-part Murphy test applies to that. My friend suggests that that's not the case, and he cites 6 cases. 3 of those are criminal cases, and in Murphy in footnote 2, it says that Murphy doesn't apply to criminal cases, so it shouldn't be a surprise that those criminal cases don't talk about Murphy. If you actually drill down on the other 3 cases, they actually either mention Murphy in their analysis or they mention fundamental error. So you don't get to circumvent the Murphy fundamental error test just because you have a mix of preserved and unpreserved comments. I'd also point out the cases he's citing, there's like a slew of preserved, objected to comments, and then maybe 2 or 3 unpreserved. In this case, we have 1 and 1. And as far as the one that was preserved, the wealth comment, I do want to point out you have the same thing where the judge gave a curative instruction. And there's been no argument that didn't cure the problem here. And then as we lay out in our brief on that, the defense's strategy was to continually portray themselves as a small, unsophisticated family business. So I think the comment was actually fair. Turning to, unless the court has any questions about those 2 issues, getting back to what's the primary issue on appeal, which deals with the admission of the felony conviction by Mr. Hopkins. I would just say the elephant in the briefing is that they wanted to use this to prove the forcible felony affirmative defense. That's question number 2 on the verdict form. And actually, they're still doing it here today. That opening you just heard, that's very similar to the closing argument that was on pages 956 and 957 of the record, which is their closing argument on the forcible felony defense. And they also opened their reply brief with this. Their belief that they were entitled to try to convince the jury of was that Mr. Hopkins was committing a felony at the time of his death. And if so, if they had been successful in showing that to the jury by the greater weight of the evidence, that they would have won this case. And they've now kind of smuggled that in, because if you go look at 956 and 957, it's very similar to what you just heard here at the opening. It's very similar to the first 2 pages of their reply brief. And the trial judge, the one who was sitting there, that's how they started off at trial about this. And we lay that out in our brief.
Right, but they certainly did start out that way, but there's no doubt the record also shows that they were trying to bring in this evidence as relevant to the $7.5 million damages claim that ended up being awarded here, which was the loss of parental guidance and presence, right?
I agree that eventually they turned to that theory to try to get the evidence in.
Right, so that's before us, right?
No, I don't disagree. It's before you. But what the issue here, though, is whether the trial judge, and I think my friend conceded this, whether the trial judge abused his discretion. And so we're looking at this under 90.403. And the judge, it's the trial judge, not the 3 of you. The trial judge gets to do the weighing under 90.403. okay? And he saw what was happening in front of him, that they wanted to use this conviction for an improper propensity purpose. They basically, Mr. Vasquez admitted it at one point, that that's what they were trying to do. That they want, and so.
But they also had a proper purpose. So let's stick with that for a moment.
Sure.
You've highlighted the standard of review of abuse of discretion here. Would you concede if the trial court had allowed this evidence in, that there would have been no abuse of discretion?
I would, except for 90.410, which
Okay.
I want to get to. I would, except for 90.410. I think this is a trial judge call that he could have gone either way, and he would have been affirmed. And it's the classic abuse of discretion. But they chose to present this first. First impressions matter. They came out of the box trying to make it relevant. They wanted their security expert to talk about it, which has nothing to do with the damages. That's how they first presented this to the judge, that their security expert needed to talk about this. And it was material and important to his testimony. Nothing about damages at the beginning. And then at some point they came up with this damages theory. I would just say, I do want to get to 90.410 because I think that's really an easy way for this court to affirm. I understand that 90.410 wasn't explicitly raised below, but I would point to Mizell v. State, where Judge Norby, you were on the panel, and this court invoked tipsy coachment to affirm on 90.403. I don't see why you couldn't do it under 90.410. The plain text of the rule makes it very clear that this evidence would have been inadmissible. I want to keep in mind, they didn't bring in witnesses to talk about the underlying, like what Mr. Hopkins did. What they wanted to put into evidence were the actual convictions and the statements at the plea colloquy, which are covered by 90.410. They didn't proffer any other evidence. And respectfully, my friend says in the reply brief that he cites this 1983 case from this court, Cruz v. State, to argue that 9410's rule of inadmissibility applies only when the conviction is offered against the person who was convicted. There's multiple problems with this argument. First of all, Mr. Hopkins was convicted, and Ms. Carter, as the personal representative of his estate, is his successor in interest. So even if we want to accept that that's the rule, it would seem that Ms. Carter it's being used against her, not in her individual capacity, but in her capacity as the representative of Mr. Hopkins' estate. So I don't think that really helps them any. Secondarily, Cruz can be distinguished on multiple grounds. There, the court held a criminal defendant is permitted to use a nolo contendere conviction to impeach one of the state's witnesses. And the court's reasoning was that section 90.6081B, not 90.410 applied because the criminal defendant wanted to use the plea to show that the witness was biased in favor of the state. Here, Kokomo did not want to use the plea to impeach Mr. Hopkins to show he was biased. There was no hearsay declaration of Mr. Hopkins that was brought in. What they wanted to use the conviction was to really show two things. One, that he committed a felony on the day an incident and they'd win on liability. And then they wanted to show that he was a bad parent at the time that the underlying criminal history was going on. On the latter, they could have brought a witness to testify about that. But the one thing they weren't allowed to do, and they didn't have any witness to testify about that, they just wanted to use the prosecutor's statements at the plea colloquy, and that was the one thing they're not allowed to use under 90.410. The other thing about the Cruz case, it's a few things, and I'll try to be quick about them. One is it was concerned about public policy and the criminal defendant's constitutional right to defend himself and cross-examine witnesses, which we don't have here. The Cruz's method of interpreting the statute is clearly atextual and purposeless and doesn't comport with the supremacy of the text principle that this court will have to follow. And furthermore, it relied on Federal Rule of Evidence 410, which actually says what the defendant wants it to say. 410 has the federal rule has different wording. It says, in a civil or criminal case, evidence of the following is not admissible against the defendant who made the plea. So that language is not in our Florida rule. So I think you can easily distinguish Cruz, and you can just affirm on the basis that the only evidence they wanted to admit, they didn't bring any eyewitness testimony. They didn't bring anybody come in they didn't ask Ms. Carter a single question about this. They didn't ask her anything about what was going on in the home. They didn't bring any witness that was going to testify. They wanted to just have the prosecutor's statement. That's what they were going to use to prove that.
You distinguished between the plea and the incarceration.
I wanted to get to that.
Yeah.
Thank you.
So why, even if we agree with you on the plea,
Right.
Why was the inadmissibility of the incarceration appropriate?
Okay, so first of all, let's go back to the judge's ruling on this. He did not prohibit the fact of absence from the children. Okay, he tried to narrowly tailor his ruling, and he made it very clear that the defendant could get into the fact that Mr. Hopkins was not with the children for that period that he was in prison, that they could put on evidence about that. But you know what? They didn't do that. Again, even though the judge told them that they were entitled to put on evidence about his estrangement from the children during that period, they didn't ask Miss Carter, the children's mother, a single question about that. And they didn't put on any other witness to talk about that. So, and I think this kind of shows what they really wanted to use this conviction for. Because the judge told them, if you want to talk about how he wasn't there, you can do that. Now, what the judge excluded them from talking about was the fact that he was actually in prison. And I think this, again, goes to his discretion under 90.403. Because if the jury is told that Mr. Hopkins is in prison, they're going to know that he had a conviction. I mean, everybody would know that. It's not like a big leap.
But on the other hand, on the probative value, I mean, the jurors could have thought, you know what, he has military service and was doing something honorable in those years, which would have been extremely probative and relevant to his parental guidance and the quality of that, right?
Well, actually, what the point our trial counsel made was that it was that fact pattern, that he was absent because of military service, that they would be entitled to move to exclude us talking extensively about his military service, because we would be trying to use that in an unfairly prejudicial manner. So I agree with you that these are where the trial judge has to make that. I don't think his military service would have been, if he was absent because of his military service, it would have been improper for us to start talking about that. And that's why I gave the Russian prison example in the brief. And again, you might not agree with this if you were sitting as a trial judge, but he's having to make these calls. And again, I want to go back to my main theme here. There's no question what they wanted to really use all of this for, and that was to prove the forcible, to use a propensity inference, which was clearly impermissible. You could be mad about what plaintiff's trial counsel asked of the expert witness, but there's no doubt what they were trying to do too in this trial. They were repeatedly trying to get the jury to find that Mr. Hopkins must have committed a felony because he had a prior conviction. And they told the judge that at the beginning. And so the judge was trying to keep that improper propensity inference out of the case. And so with the fact of incarceration, what he came up with was, you can go into all how he wasn't there. But if that was really what they wanted to do, why did they not ask a single question of Ms. Carter about that? Why did they not put on a single witness to talk about that, if that was so important to their case? And I would suggest to you the trial judge was pretty smart. He knew what was going on. Let's see, I might not have, unless the court has, let me just see if I could look over my notes real quick. I think I just, again, on the wealth comment, this is what the curative instruction was that was requested by defense counsel. The jury is directed to disregard the last statement and not to consider it during deliberations. There's no argument in the brief, just like there's no argument on the improv. There was no argument to the trial judge then on either of these comments as to why the curative instructions he gave were insufficient. And the way curative instructions are, respectfully, is that, you know, when there's an error, the judge has to come up with a remedy. And it's up to the trial judge to pick it. And what they're telling you is the judge has to give a mistrial remedy. That's not the law. The judge can pick a lesser remedy. And he actually gave the curative instructions they wanted. And they never argued to him why those were insufficient to cure the problem that happened below. And I think you have to respect the trial judge who was there and who saw the jury and was able to make that determination that they were fine. Unless the court has any more questions, thank you for allowing me to argue today.
Thank you, counsel.
So, Your Honors, there's a lot there. Excuse me. I'm going to try and move quickly. So I'll start with the 90-410 issue on the prior convictions. Counsel did everything except tell you what the court held in Cruz, and it's very important, so I want to give you that in fine point. So the court there said the authority had analyzed, quote, finally foreclosed any rational contention that the statute was designed to bar at any trial all evidence of statements made in connection with police, and that's exactly the way they're trying to use it here. Instead, the court held, quote, Section 9410 was intended to preclude evidence of thwarted plea negotiations only if such evidence is introduced at a later proceeding against the person who withdrew the plea, provided he is a party. Now, in this case, that would be the deceased. The deceased isn't a party here. This case is brought on behalf of his surviving minor children for damages, and it's perfectly admissible against them. And he's trying to distinguish Cruz on the basis of the facts there. In Cruz, the individual who had made the plea was at least involved at the trial where this evidence was entered. He was testifying, and it was brought up against him, but he wasn't a party in that case. Here, we're one step even further removed. Obviously, the deceased wasn't involved at this trial. So if we're talking about it from a policy standpoint, the rationale that was in place in Cruz certainly applies here, which is that the rule exists to promote plea negotiations, and that policy implication just isn't applied in a situation like this when it's offered in a totally separate proceeding against different individuals. And I think we should also note that it's currently binding precedent of the first DCA. That's what the rule is. That's how the rule's been interpreted. So next, I'll touch on this very briefly. With respect to the priors, he spent a lot of time talking about what he thinks we actually wanted to use the evidence for. And as Judge Rowe said, there was a proper purpose here. So we can talk all day about what other purposes there might have been. If we're talking about Rule 404, that just doesn't matter. Under that exclusionary rule, it excludes evidence only where it's relevant solely for that improper purpose. We have a proper purpose here, which puts us under Rule 403, and I spoke at length why I think there's no real propensity harm here and that the probative value outweighs that. And, Your Honors, on that I'll also note, if that concern was there, and say we had a different world here where the court recognized the threshold relevance in the first instance, sided with us. Plaintiff at that point could have asked for a limiting instruction to say, as you often do in 404 cases, that there's a proper purpose for this evidence. That proper purpose is damages. You can't consider it for propensity, and we wouldn't have objected to an instruction like that. As to the incarceration, the argument is that it was a narrow ruling. They were allowed to hear that he was absent. And that, asking why didn't we ask more questions about that? Well, Your Honors, if you look at the record, it's because plaintiff's counsel asked plaintiff herself those questions. Her answers were they still talked on the phone every day. He was still an amazing father during that time period. Defense counsel knew what her answers were going to be. It wouldn't have made a lot of sense to go up there, ask those same questions, and get those answers that we thought didn't reflect reality at all, right? Because that's the way the discussion had been limited, was to those four corners. We knew what those answers were going to be. Those answers didn't give the full picture, so we stayed away from those answers. And the last thing I want to address, and this goes back to the impeachment issue. So first, real quickly, he says the court never gave an adverse ruling that's on appeal. That's just not true. The court denied the motion for a new trial where we renewed this issue of the improper impeachment. So there's your denial right there. And he provided this supplemental authority a few days ago about preservation, but in that case, there was no motion for mistrial. In the cases that case discusses, there was also no motion for mistrial. In this case, there was. So that's what we're operating from, is that proper remedy was asked for. And I want to give you one cite on this real quickly. This is Henry versus Beacon. It's cited in our briefs. The court there, very similar facts, sustained an appellant's objection, instructed the jury to disregard, but failed to expressly rule on appellant's motion for mistrial, which could potentially be what we have here. The court said the curative's insufficient, said, quote, the court should have either granted appellant's motion for mistrial as an adequate cure, or should have granted the motion for a new trial that was on the same grounds. And that case is most similar factually to what we have here, not appellant's case where no motion for mistrial at all was made. I think our remedy was clearly stated below. So the last thing I'll say, Your Honors, is that the verdict in this case was a product of the improper comments and errors that were made below, and for that reason, it can't stand. So we'd ask this court to reverse the judgment below and to remand for a new trial on all issues. Thank you, Your Honors.
Thank you, counsel. Thank you all. This court is adjourned.
All rise.